Good morning. My name is Amy Klocke with the Goosmann Law Firm, and I am here today to talk about family law in a nutshell. And the purpose of this webinar is just to give an overview of the areas of practice of family law. And before I get started, I of course have to give the disclaimer. Goosmann Law Firm engages in the practice of law and provides legal advice and opinions. The information contained in this presentation is not and should not be construed to constitute legal advice for you or your company. You should engage counsel to analyze your situation. So now that we've gotten that out of the way, we can move on to the topics of family law. Today I will just give a brief overview of divorce, child custody, modification orders, paternity, adoption, gestational carrier agreements, and premarital agreements. And I do have Jamie here with me today, and she has some questions that were pre-submitted, and she will ask those at the appropriate time during the webinar. So we'll go ahead and get started, and we will start talking about divorce. Now, if someone, either the petitioner or respondent, needs to be a resident of the state that the divorce is filed in, jurisdiction has to be established over both parties. So that's the first hurdle that you have to cross in order to even file for divorce in the state. So if you and your spouse live in different states, you will certainly want to talk to the attorney about that issue to make sure that jurisdiction has been established over the parties, and you also have to have a length of time for jurisdiction. So for example, in Iowa, it's 1 year. South Dakota does not have a time limit, but of course you cannot just move to South Dakota for the purpose of obtaining a divorce. So your attorney will ask you questions about jurisdiction to make sure that the state you're filing in is the correct state that you need to have or need to be filing in. Now, a purpose of a divorce is really the division of assets and liabilities. Courts treat divorce like a business deal. There generally is not any emotional fault considered by the judges. But saying that, Iowa and Nebraska are no-fault states, but South Dakota is a fault state and will consider several factors in making a divorce determination. They will look at whether or not there's adultery, extreme cruelty, alcoholism, a felony conviction, neglect, or desertion. Okay, so our next area that we will talk about is alimony. Alimony is not as common as it used to be, simply because both spouses are more likely to work now. There are 3 types of alimony: traditional, rehabilitative, and reimbursement. And I'll go through and just briefly describe the differences of those types. The first is traditional, which is very commonly thought of, and that's a situation where you may have a long-term marriage where one spouse perhaps stayed home to raise children, and now after 30 years of marriage is getting divorced and does not have the ability to go out and get a job and provide for themselves. In that situation, the court may order traditional alimony for a certain length of time, or depending upon remarriage or something like that, will cause it to end. Rehabilitative alimony is a temporary alimony that allows one of the parties to seek education or some kind of training so that they can be more readily employed and support themselves in the lifestyle that they were accustomed to living. And the last type is called reimbursement alimony. And a common situation with reimbursement alimony is where one spouse perhaps worked while the other spouse went through college or some kind of advanced medical school, law school. And once they finish schooling, then they file for divorce. Then the court will typically order a reimbursement alimony to give something to that spouse for putting the other spouse through school to better their lives. The next area is child custody. And obviously it's best if the parties can agree to a child custody arrangement, because parties are more likely to follow an agreement that they came to rather than an agreement, or excuse me, an imposition by the court to follow an agreement. But if the parties cannot agree, then the court will make that determination. The court will look at the best interest of the child, and the options that the court can have is regarding legal custody and physical custody. Most common legal custody is joint, so both parents would have say in the child's medical care, education, things of that nature. But then physical custody, it can be joint, where it's essentially a 50-50 equally shared time, or primary care can be with one parent, and the other parent would be the non-custodial parent who would be entitled to parenting time with that child. The court will then also set child support when determining child custody, and to do that, the court will use the child support guidelines, and that is set out by each state. And basically, the court will put in the information such as the parent's income, any kind of deductions that they would be entitled to, and determine the amount of child support for the parent to pay, the non-custodial parent to pay, or even the joint parent to pay. It is a myth that if there's joint physical custody, that there is no child support.
And there's also the myth that mothers always get full custody. You hear that all the time, where mothers automatically get full custody, and is that true, or?
No, the court cannot consider the gender of the parents, whether it's the mother or father, when determining custody. The court will look at several factors to determine what is the best interest of the child. And that may be to be with the mother or the father, or equally shared time between both parents. Now, Jamie, the factors that I referred to would be the historical primary caretaker. So if you have one parent who works 80 hours a week and is gone all the time, and the other parent is the historical primary caretaker, the court will take that into account when making a decision. The court will also look at the parents promoting the relationship between the child and the non-custodial parent. Parental alienation or interference, which is closely related to that. Sometimes when parents are extremely upset or strongly dislike their ex or cannot work very easily with them, they will try to, quote, punish the other parent by trying to get in the way of the relationship between that parent and child. And that backfires on that parent because the judge will count that against them when determining custody, because the court wants the child to have a relationship with both parents. The court will also look at the existence of any domestic violence, domestic abuse, failure to pay child support. But I would like to note this is not tied in with visitation. Of course, a parent is ordered to pay child support and is expected to pay their child support, but the court will not eliminate visitation with the child as a punishment for not paying the child support. The court will look at any religion, moral misconduct, good role model. And I would like to point out here where earlier I said in no fault states, the judge will not look at any fault when determining the outcome of a divorce. It can play into child custody. So if you have a parent that is engaging in inappropriate or illegal behaviors, the court will consider that when determining the better parent to raise or be the custodial parent of the child. And then the last factor that the court will consider is child's preference. And sometimes people think if the child says they want to be with one parent, the court will automatically accept that. But it is just one of the factors that the court will look at. Obviously, the older the child is, the more weight that the court would give to that child's preference. The next area is modification. Now, the court's intent once a divorce child custody case happens is that is the final resolution in court. But unfortunately, that's not always the case because circumstances can change. I would like to note that any divorce settlements, those are permanent unless you could show some type of fraud or something along those lines. So you can't go back to court to modify how the court divided up the assets or liabilities. But child custody or child support can be modified if there's a substantial change in circumstances. That means there must be a really big change, such as a job change, with income change, a parent moving, perhaps parental alienation. But before the court will consider changing child custody or support, there must be a substantial change. The income change must be 10% or more, and the courts do not like to change custody because they want a stable environment for the children. They want the children to know that this is how their living situation will be, and the court will only disrupt that if there's a major change in circumstances.
Amy, what happens if, let's say my ex moves away? I mean, what do I do?
Right. If your former spouse moves, usually the general guideline is 150 miles or more. There's no law that says if they do move that distance, the court will automatically change custody, but that would constitute a substantial change in circumstances, and that would at least get you back into court where the judge could determine the best interest of the child. If that would be to move and remain with that primary care parent, to change some visitation. Let's say that you had midweek visitation and they move 150 miles away. That's going to be very difficult to do. So the judge may grant longer summer vacation or over winter break and make some changes that way. Or it's possible the judge may change custody altogether. It would just depend on the circumstances of the case. The next area is paternity, and this is becoming more common because more unmarried couples are having children together. A couple, or I guess a party, would need to file a petition to establish paternity and support in court, similar way actually to a child custody hearing. It's very similar. The alternative is a petition to disestablish paternity. So if a parent, their name, let's say the father's name is on the birth certificate and he does not think he's the father, he could file a petition to disestablish paternity because paternity was established in the birth certificate. But either way, then the court can handle the child custody, support, visitation between the unmarried parents of the child. And like I said before, it's almost identical to how you would handle if a married couple were divorcing and signing on the same terms. There is no division of assets with a divorce because there's no marital property because they were not married. So the court is limited to issues surrounding the child or children. The next area of practice is adoption, and the most common adoption would be step-parent adoption. Typically, we see a situation where one of the parents is not involved in the child's life. Mom or dad who does have the child meets someone and wants to get married, and that parent essentially has become mom or dad for that child and wants to legally adopt the child. And obviously, if the parent who is not around agrees, then it's a fairly straightforward process. Even if that parent is around and not willing to consent, it can still be accomplished, but it's obviously a tougher battle to do that. Adult adoption is allowed in Iowa and Nebraska as well, and we don't see that as often, but it certainly does happen from time to time.
So, Amy, why would an adult want to be adopted?
Good question, Jamie, but there are actually some various reasons that I have found that adults want to be adopted. For example, maybe the parent is a member of a Native American tribe and that child wants to enroll in the tribe and was raised by this individual and wants to embrace the culture and be a part of that parent's life legally. Other times you might have foster children who are now adults and they've always been a part of the family, but they actually want to legally be a part of that family. They want to say, this is my mother or father, even though it doesn't usually do a lot legally for the person. Just knowing that that relationship is established under the law is what people are looking for. And of course, that can get into some probate issues if you are legally adopted and you have rights to take under a will, but we'll save that for another webinar to get into further. Gestational carrier agreements, they're becoming more and more common. The surrounding tri-state area does not have any laws or cases on this issue, so it's a completely gray area of law. But what typically happens, a couple will be trying to have a child and let's say the woman cannot carry a baby, so they will get a donor egg, and either the mom will carry the child or the donor will carry the child. It just depends on the situation. A lot of times the child will have no genetic link to the carrier. The carrier is simply to carry the child to birth, even though there's no genetic link. What we have been doing in Iowa is a second parent adoption. So when the carrier, who has no genetic link, goes into the hospital and has the child, the father, who is the genetic father, his name is listed on the birth certificate, and then the birth mom has to be listed on the birth certificate. So then a second parent adoption, like a step parent adoption, would be done. So the mother, who is the genetic mother, would then be the legal mother of this child. And again, there's no laws on this issue, so it's a very gray area, but it's an up-and-coming area as well. The last area that I want to touch on are premarital agreements. Those are becoming more common too as people enter into second marriages, or they have more assets before they get married because they've waited longer to get married. Premarital agreement simply helps couples protect assets in case of divorce. And this is recommended if one or both of the parties have a lot of assets, such as a business or farmland or retirement accounts. It just protects both, one or both, I guess both really, because you know the rules before you enter into the marriage in case something does happen. You don't have to go through a messy divorce fighting over your premarital assets or assets that have become marital due to the marriage. Inheritance issues, it's kind of a good question. Under the law, if you inherit something, your spouse is not automatically entitled to half of that, let's say. But the premarital agreement really does make it a lot easier. It's spelled out clearly that the parties agreeing they will not attempt to go after any kind of inherited property. So at this point, we do not need to submit questions because some were pre-submitted to Jamie, the chat box, for this webinar. And that's all that we have today. Be sure to tune in for the next webinar. Thank you very much.